We are very confident in our case. We think that the evidence at trial was very strong. Unlike other voter ID cases where, particularly the Indiana one that gets thrown around a lot, where there were no voters put forward who would have been unable to vote because of the voter ID law. In this case, we did have people like Ms. Brown, like Mr. Holloway, who would have been completely unable to vote in November 2012 under this voter ID law. And we have a lot more evidence about the lack of any kind of unlawful voting behavior that this law would prevent. You have a lot of individual examples and details about the ways in which voters are burdened by this law and the ways in which voters who have lived for years without ID. I know there's a lot of mythology out there that everyone needs an ID, but, you know, as Judge Adelamn found in the case, these are voters who don't fly on airplanes, don't cash checks, don't drive, and haven't had a need for an ID, don't necessarily have birth certificates or birth certificates DMV will accept, don't have paid time off work to get to DMV during daytime hours, other problems like that he found. And also that there was a lot of evidence, including expert testimony about quote-unquote voter fraud or the lack thereof in Wisconsin, particularly, again, the only kind of improper voting behavior this would prevent, which is impersonation. You know, the people talk about voter fraud as one lump sum, maybe throw out double voting. There are a lot of double voters who register and vote with their ID card, so it would be irrelevant. The only kind of voter fraud that this could prevent is essentially non-existent, as the judge found. And we think, you know, each state and each place where it's being challenged needs to look at their own situation and gather their own evidence, but we think it's a good roadmap.
All right. Karyn Rotker, thanks very much for joining us.
Thanks for inviting me.